And look, David has a strong interest in this subject. He's a member of Exit. He's an ethicist and has a scientific background and worked in the public service. One of the leading commentators on dying with dignity. So, David, without any further ado, I'll pass it over to you. And I think I shouldn't need to do anything else on share screen. You should be able to bring yours up again, I hope.
If there's any problems, Alex, I'll let you know.
Yeah.
Thank you very much, Alex, and good afternoon, everybody. I'm very pleased to be presenting here today. I'll just try and share a screen, and that presentation should last for about 25 minutes or so. So let's see what we can come up with.
Yep.
Is that clear, Alex?
Yep, it's working. So I will take myself off the screen now.
Fantastic.
I'll be here. Thanks, David.
Well, good afternoon, everybody. It's a very opportune time for me to be talking about voluntary assisted dying in the ACT. I'd like to thank Alex for inviting me to speak today. I head Exit ACT here in Canberra, and we are one of the two groups here representing voluntary assisted dying advocates in Canberra. A quick warning, this presentation will involve a discussion of death, suicide, voluntary assisted dying. So if you have any irrational concerns about these issues, please see your health professional. I'd also like to indicate that I have a chest infection at the moment, so I might need to break occasionally to cough and splutter, and hopefully I'll mute myself before I do that. Hope you have some forbearance there. So what am I going to do today in the presentation? I'll give you a bit of a background into voluntary assisted dying. The what, the why me, the why now, and a theoretical thought experiment challenge that will hopefully inspire you all to think a little bit differently. I'll be informing you today, challenging you to think a little better, and hopefully by the end of it, you might be more available to thinking about a more progressive voluntary assisted dying regulatory system. I'll be talking about the human rights and medical models for voluntary assisted dying, what's happened in the Australian states, the views of VAD advocates, and regulation overseas. I'll be only discussing these briefly because these are probably all talks in themselves. And then finally, I'll be talking about the VAD regulatory system for the ACT. It's a good system, but the legislation does not nearly respect individual autonomy, and many people will miss out. Many people will suffer. If you look at the Exit International website, and this website here, Ethical Rights, you can find Exit's more information about our comprehensive Exit ACT submission to the ACT government. And I've just drafted a book, Thinking Smarter, which is currently with ANU Press, that looks at critical thinking, science and ethical issues, including voluntary assisted dying. So what is voluntary assisted dying, VAD? Overseas, it might be known as physician-assisted death or suicide. In Canada, it's known as medical aid in dying. It's also known as voluntary euthanasia. VAD advocates would define it as follows: a deliberate act intended to cause the death of an individual at that individual's request, what they're seeing as being in their best interest. And clearly the emphasis on the individual is apparent here. It's all about what is right for a person. Even Wikipedia does a reasonable definition: the ending of a person's life at their request in order to relieve them of suffering. But the ACT legislation doesn't quite get it right. It has been copied from the legislation in the other Australian states. It's based on the wrong model. It defines voluntary assisted dying as a medical process, and I can't realise why it needs to be a medical process if you're just drinking a solution that might cause your death because you're suffering, that gives an eligible individual, and that should raise a few red flags. It means some individuals are not going to be eligible and some individuals are going to be required to suffer, the option to end their suffering by choosing to die through the administration of an approved substance. And that sounds like a lot of bureaucracy, and the ACT Act does have a lot of bureaucracy. Bureaucracy administration is important, but the emphasis on the ACT Act is more about administration and doing what the lawyers and doctors want to do, and it's not an act that benefits people who are suffering and who want voluntary assisted dying. So why me? I've been involved in the voluntary assisted dying movement for 27 years. Since 1997, when Philip Nitschke founded Exit International. Now, Philip is the first doctor in the world to have given a legal lethal dose of a drug to help someone to die when they were suffering under the Northern Territory's then legislation. There's over 200 members in the ACT, many thousands worldwide, and Exit provides information and support to members on end-of-life issues. Other groups in this space include the Dying with Dignity ACT group, which is very much concerned with legislative reform here in the ACT, and we work very closely with them. And Go Gentle is a group founded by Andrew Denton that has been advocating for voluntary assisted dying around Australia. Now, I'm essentially a utilitarian, which means I'm very concerned about generating maximum benefits and creating the greatest happiness for the greatest number of people. I'm not in favour of leaving people out of a voluntary assisted dying scheme that will require some people to suffer. I support individual autonomy. I can't have anyone tell me who I should sleep with, whether I can have an abortion, or whether I can have voluntary assisted dying. It's my life. And from my science and ethics perspective, I'm coming from a critical thinking perspective, again, also written about in my book. So I'm going to be challenging everyone to think a little bit differently. Important, I want to say that unsupported opinions don't count on public policy issues, whether they are vaccine, climate change, or voluntary assisted dying. You are only entitled to what you can argue for and what you have evidence for. So I'd like us all to think now. In the ACT legislation, it's basically available to terminally ill people only. Down here. It's also, now I'd like you to also think about the yellow highlighted text. What if you're not terminally ill, but suffering intolerably? What if you have dementia? Should you be eligible for voluntary assisted dying? At the moment, in the ACT, the answer is no. But that yellow highlighted text, those conditions, are what we would like to push further to amend the ACT Act as soon as possible and before 2031, which is when the next Act amendments can occur. But also think about these other issues. What if a person were depressed, or pregnant, or a criminal, or a child? Should they be allowed have access to voluntary assisted dying if they were suffering unbearably? Should we be requiring them to suffer under legislation as they are at the moment? So why now? Well, it's been a sordid history here. Liberals Kevin Andrews and Erica Betts and Labor's Tony Burke helped overturn the Northern Territory's Rights of the Terminally Ill Act in 1995, and they enacted the Euthanasia Laws Act 1997. That act also banned the ACT from legislating, until that was overturned by the Commonwealth's Restoring Territory Rights Act 2022. And ACT politicians David Pocock, Katie Gallagher, Alicia Payne, Andrew Lee, David Smith were all instrumental in supporting that act. Interestingly, David Smith opposes voluntary assisted dying, but realised that this was about restoring the rights of the ACT to legislate for voluntary assisted dying, so he supported the act. Now, the ACT passed this Voluntary Assisted Dying Act on 5 June, just a few weeks ago. It commences at the end of November next year. A review will take 3 years, then amendments, debate in the Assembly, committee consideration, and come into effect. So no changes on this current Act will probably occur until 2031 unless we act now. And I'm going to be talking about that at the end. Now, the VAD Act in the ACT, I think, is the best in Australia. Tara Chain did an excellent job of sponsoring the VAD bill, but she was handicapped by the politics in the ACT. But overall, the ACT copied the wrong VAD model. We basically copied the model that's available in the other Australian states, which is based on doctors telling you whether you are sick enough to die or not. And what else happens in Canberra at the moment? Well, Canberrans do suicide. Many Canberrans, Exit members and others, have legal lethal drugs and do suicide when the time is such that they think that their life is no longer worth living, when their quality of life is below a threshold that they can bear. That happens in the absence of regulation. In addition, last year, I'm aware of 2 instances where police, after 11 o'clock at night, turned up on the doorstep of 2 elderly women because they were alleged to have legal lethal substances. They were doing a welfare check. Quite the contrary, these people were quite distressed that police were knocking on their door after 11 o'clock at night. That is not a good use of police resources, and very unfortunate that that sort of policy should occur in Canberra. So here I'm going to be challenging everyone with a thought experiment. Imagine that abortion were illegal in the ACT. Of course, it is legal, but imagine if it were illegal. It is then made legal, but only for some people. And the people it's made legal for are adult raped women with decision-making capacity. So excluded are all those non-adult women who have not been raped and people without decision-making capacity. How should we acknowledge the government of the day? Should we congratulate them for making abortion legal? Or should we criticise them for discriminating against people who have not been raped and people who are intellectually disabled or don't have decision-making capacity? So I think you might know where this is going. Let's swap out VAD for abortion and terminally ill for raped, and we have exactly the same argument. So now excluded are non-adult people who are not terminally ill and people without decision-making capacity. If you're suffering unbearably but not terminally ill, or if you have dementia, you cannot access voluntary assisted dying under this ACT legislation. How should we acknowledge the government of the day? If all women have a right to abortion, then all people should have the right to VAD. Should we be saying, congratulations, ACT government, great job on developing legislation? Or should we be saying, my goodness, you've discriminated terribly there. So many people will suffer. That's an issue for us all to think about, because the ACT government will be acting on community sentiment. We've got to change our views so we can change their view. Let's talk about the medical model that's been used in Australian states. As defined by the British Medical Journal, the medical model for voluntary assisted dying is something like doctors will counsel and refer patients, and ascending doctors will do assessments and prescribe the drugs. The Australian medical model goes even further. It limits it to, if you look at the yellow text there, adult resident patients and people suffering unbearably and terminally ill and with a limited life expectancy. Now, the green text, highlight text there, has been crossed out because that's the only one of the ACT differences from state legislation in the medical model. In the ACT, there is no requirement for a limited life expectancy. There's no time to death requirement. That's good. Why should you have to have only 6 months left to live to be eligible for voluntary assisted dying? You could be suffering unbearably for 10 years. And in New South Wales or other states, they'll be saying, well, tough, you've got to suffer for 9 years and 6 months before you're eligible. Unacceptable, inhumane, uncivilised. And in this medical model, the doctors are effectively society's judge of what makes a life worth living. It's not up to the patient. Doctors will be counselling and referring and assessing and prescribing. That's normal things doctors do, but in the context of voluntary assisted dying, they are the judge of whether your life is worth living. It's inconsistent with individual autonomy. It's inconsistent with patient's dignity. And what the ACT has done is probably all that it could do in an election year. It got through politically palatable legislation in an election year, but still it's not good enough. I want to congratulate the ACT government for getting legislation up, but really it hasn't gone nearly far enough. And being an ethicist and one who wants to make the world a better place, I want to focus on what could be. In this instance, too many people are ineligible for VAD rather than what is. The pundits around Australia have often said, as the legislation is introduced into every state, that legislation, oh, it's fantastic. The government's done a great job. Fantastic legislation. Well, no, it's not fantastic. Too many people are ineligible. Why are we forcing people to suffer?
I think Alex Gosman should be talking.
I think somebody has their microphone on.
Yeah, somebody has your microphone on. They just referred to me. Can they please mute?
Okay. Medical model issues. So what happens in the ACT, Victoria and New South Wales for a person to be eligible is everything there that's not in green. You have to be assessed by 2 doctors who have to have an advanced and progressive disease or illness that is expected to cause death. I think that means terminally ill, but who the heck knows? It's not well defined in the Act. You have to be suffering intolerably. You have to be an adult. You have to be a resident in the state for more than 12 months. And you cannot have a mental illness or disability unless you meet all other criteria. And the green highlighted text is where the ACT Act is better than that in the States. In the ACT, you don't need to have 2 doctors. You can have a doctor and a nurse health practitioner. You don't need the life expectancy criterion, point D. And also in the ACT, if you're in a nursing home or advanced care facility, aged care facility, there are protections for patients in those institutions if the institution objects to voluntary assisted dying. Before, they could have just ignored your request of VAD, but now they have to refer you to an appropriate authority. That is good. So the ACT Act is better than that in the States. The human rights model, however, is far better, and that's what legislation should be based on, but is not. All people have the right to access VAD so that their quality of life is not reduced below what they consider to be an acceptable threshold. Again, that puts every person's life back in the hands of themselves. It is ethical best practice. It respects individual autonomy. Everyone is responsible for their own lives, not a doctor telling you whether you're sick enough. And it respects dignity and personal beliefs. It only needs 3 eligibility criteria: importantly, decision-making capacity of well-informed individuals who make a voluntary decision. And there are 4 other issues that are particularly pertinent for exit members. What if you're suffering unbearably, as I've mentioned, but not terminally ill? That should be sufficient but unnecessary as an eligibility criterion. If you have unbearable suffering, that should be sufficient. You might want to have an advanced care directive or a VAD attorney act on your behalf. An advanced care directive would indicate the conditions under which you would want voluntary assisted dying in the future when you don't have decision-making capacity. For example, if in some years' time I cannot recognise my family, my advanced care directive should say that in those circumstances, David would want voluntary assisted dying. Or should we have a VAD attorney act on my behalf? Now, when the ACT Act was legislated, Dr Maritza Patterson, MLA, tried to put in some amendments, or she developed some amendments that would allow a VAD attorney to act, but only after you'd gone through the whole VAD regulatory process. And at the last stage, before you say, yes, give me the injection now, you lose decision-making capacity, then you've got to get a power of attorney set up, and other people and lawyers and doctors involved, get your power of attorney set up, and then you could have voluntary assisted dying. Not good enough. If a VAD attorney can act on your behalf at the last stage of voluntary assisted dying, they should be able to act on your behalf at any stage of voluntary assisted dying. There are also issues of person with advanced age. In 2018, 104-year-old Dr David Goodall went to Switzerland to die. He was a Perth scientist. He had to go to Switzerland to die because he was not ill. There was no legislation at the time, but he had had enough of life. It was time for him to go. He had so many little ailments, but he was not terminally ill. Would he be able to have access to voluntary assisted dying in Australia under current legislation? No. And palliative care. My mother spent 3 weeks at one of the best palliative care facilities in Sydney, looking at a white ceiling, ready to die, and her television didn't work. Not good enough. If you were of advanced age, and if you were in palliative care, you wouldn't have the time to get through a VAD regulatory system around Australia anyhow. Not just, you would require a month or 2. People often aren't in palliative care for a month or 2. So legislation around Australia needs some significant overhauls. Now, let's look briefly at what VAD advocates thought. 3 years ago, I surveyed VAD advocates around the world. And I asked them one question: which of the following would you consider necessary for a person to be eligible for voluntary assisted dying? Now, the bottom 3 criteria there, voluntary, well-informed, decision-making capacity, were overwhelmingly supported by VAD advocates. All 10 of those criteria constitute the medical model. But the top 4, being a citizen or resident, having 2 doctors approve an individual's request, being terminally ill, having limited life expectancy, are highlighted as massive safeguards for voluntary assisted dying regulatory regimes around the country. They are the eligibility criterion that advocates and people who want voluntary assisted dying do not want. And yet jurisdictions boast about these as the magnificent safeguards. These are not safeguards. These are euphemisms for invidious discrimination. People are being discriminated on this basis when they are suffering. And I don't know why. Competent legislators should be able to legislate on the bottom 3 regulatory criteria only. We also asked another question in the survey, and I'll read out the question. Assuming that a person has decision-making capacity and requests voluntary assisted dying, which of the following should make someone immediately eligible? And the 2 at the bottom here are advance directive and unbearable suffering. If you heard an advance directive saying, I want voluntary assisted dying under these circumstances, or you are suffering unbearably, everyone thinks you should have access to voluntary assisted dying. Also, majority support were being in palliative care and being of advanced years. That's what voluntary assisted dying advocates want, but those aren't legislated for around Australia. In all the consultation periods, in all the states and in the ACT, that point's been made repeatedly and it's been repeatedly ignored. So let's look what happens internationally, because as I've indicated, what happened in the ACT has been poorly copying the legislation in the Australian states with some minor improvements. Overseas, we have 13 countries here who all allow voluntary assisted dying to some extent. In 2 countries, Germany and Switzerland, you don't need to be ill. In 9 countries here, you don't need a terminal illness. In Australia and the USA, you need to be terminally ill. But in 9 countries, unbearable suffering is sufficient. And in 11 countries, the unbearable suffering is sufficient. But Australia and the US, sorry, you've got to be terminally ill. A request can be included in an advanced health directive in 4 countries as well. Now, international best practice is not ethically perfect, but it's far better than what has been legislated in the Australian states and the ACT. Then again, the Australian states and the ACT, it's the first time try at developing this legislation. But at first cut, they could have done a better job. So what happened on the 3rd of November? Or what will happen on the 3rd of November next year? That's when the ACT VAD Act commences, even though it was passed a couple of weeks ago. There were substantial consultation processes. There was a select committee set up by the Legislative Assembly, and many organisations and individuals made submissions. In the end, the state VAD legislation was basically copied across to the ACT with minor improvements. The lawyers who developed the legislation in the Australian states were instrumental in getting pretty much the same legislation in the ACT. And those same lawyers will no doubt be employed to train the doctors to operate and administer the ACT regulatory system. It is a shame that doctors will be overseeing the regulatory system here in the ACT. Up until 2018, no professional doctors group was supportive of voluntary assisted dying. We can't have doctors killing patients, but now not only are they supportive of it, they're the ones administering the process, and the lawyers are overseeing the process. In the principles of the ACT Act are in Section 7. And they are all sounding fantastic. That a person be protected from coercion, that human life is important, that dignity, individual autonomy, personal and cultural beliefs are respected. All fantastic principles. But the principles in green are not reflected in the Act. You do not have individual autonomy if a doctor can overrule your individual decision. If your personal belief is that you would want voluntary assisted dying in a certain circumstance, that is not respected if a doctor overrules you. Section 11 of the Act has the eligibility criteria as per the ACT medical model. We only need decision-making capacity and voluntary, but the ACT adds on being an adult, having an advanced, progressive and expected to cause death disease, that you'd be suffering intolerably and you'd be a resident. All that happens in the first 10 pages. The other 100 pages of the Act is normal bureaucratic process. It's process, requests, liability, conscientious objections, oversight boards, operators, Act reviews, amendments, and so on. Really, this Act, while it is important to have this Act, it is important first cut. It's important in the ACT that this was better than what was in the States, but it's still very much about bureaucracy. It's not an Act for people who might want to use it. It's an Act for those who want to administer it, and for the doctors and lawyers who are a controller of individuals under this regulatory system. You do need bureaucracy, you do need administration, but from my perspective, it's the people who are suffering that do not receive as much attention under this Act as they should. So where to from here? The two priorities for me and for the Exit ACT and the Dying with Dignity ACT group before 2031. We would like to make sure that people who are suffering intolerably but not terminally ill can access voluntary assisted dying. We'd like to make sure that those people who lose decision-making capacity at any stage of the voluntary assisted dying process can access voluntary assisted dying, not just after you've gone through the whole process yourself and then lose decision-making capacity at the last stage. So whether it be an advanced care directive or a VAD power of attorney, something must be better. Under the moniker of a campaign slogan of Canberrans for a Good Death, we hope to make some changes. We hope to survey election candidates in the lead up to the election and assess their views and inform Canberrans about who is supportive of a more progressive voluntary assisted dying regulatory system. So in summary, VAD is important for all people with decision-making capacity and who are well informed to make a voluntary decision. People suffering intolerably but not terminally ill, and people who lose decision-making capacity should be eligible. In addition, advanced care directives and power of attorney provisions should be available so that people in palliative care and the elderly can access voluntary assisted dying. Moreover, doctors shouldn't be required. My life is my life. It's not my doctors to assess me as to whether my life is worth living or not. It's my decision. So what can I say? I can say less restrictive VAD legislation, more progressive legislation, does not discriminate. It allows people to mitigate their suffering and make the world a better place. And I'll leave you with a couple of questions. And hopefully I've informed you about voluntary assisted dying, encouraged you to think, and maybe led you to a more progressive form of voluntary assisted dying. So the questions I should leave you with are the following. Should anybody be ineligible for voluntary assisted dying? Should anybody ever be required to suffer? And if you answer yes to either of those, you must also think about why. So thank you, everybody, and thank you, Alex.
Great, David. Well, thank you very much. That was great, and you seem to have got through without your chest infection too much. And look, I've also just got to thank a colleague of David's, Jenny. Jenny is a yoga colleague of mine. It was her 2 weeks ago who put me on to David. So Jenny, thanks very much for all your help. So look, there's a lot of questions here, so we'll gradually work through them, David. And I might even try to combine some, but I might start off with the question from Stu. We in general try to prevent suicide. What are the boundaries between that and suicide?
In many cases, VAD can be suicide. When Dr. David Goodall died at 104 years old, that was a suicide. Effectively, he got someone else to inject him with the drug, but that was a choice. So rational suicide can be VAD, can't really be here. It can be here, sorry, it can be here in the ACT. You can self-administer a drug. Now, I do want to distinguish it from the irrational suicides of younger people who might be suffering a mental illness, who might have lost a job, a partner, and those suicides are terrible. And what I'm talking about today here is clearly not the same as that. I'm talking about people who are suffering unbearably, with no hope left, whose suffering will get worse, and the ACT legislation does not allow them to alleviate or mitigate their suffering.
Okay, David, can I ask a situation, and I'm sure that a number of people have been in it, where they have a loved one who's in hospital, who's being kept alive on a respirator. Their mental facilities are no longer there, and then they're asked by a doctor, what's your choice? Do you want us to take further intervention or turn off the respirator? How does that sort of work with that, or does that come into your living will?
Well, that's, from what I understand, that's allowed now, because removal of life support is allowed under an advanced care directive. Now, interestingly, the consequence of both that action, removing life support, or giving someone a drug is the same. The person will die.
Yep.
So how can it be different ethically if I remove someone from life support or give them a drug and they're both in the same position where they're not recovering, they might be in a coma, they might have dementia, never recovering, they might have a brain disease, never recovering? Why should we let them suffer if it's against what they would have wanted? And if they can't make the decision, we let their family make the decision, basically giving them an unofficial power of attorney. Now, I'm not a lawyer, and I might be saying something slightly incorrectly here, but that's my general interpretation of what's going on.
Yeah, no, that sounds the way I would have read it. A question from Michelle: are there any VAD attorneys in the ACT, or will it be an emerging trend?
So VAD attorneys, I'm not sure what that means. There are no VAD attorneys in the ACT now, because a power of attorney will not allow you to say, in 10 years' time, when I can't recognise my family, please give me a lethal drug. That cannot occur. Advanced health directives do not work for voluntary assisted dying in the ACT at the moment. I can't say, when I'm in a home and I can't recognise anybody, please cause my death. If I say that in an advanced health directive, or give someone a power of attorney to say that, it has no validity anywhere in Australia.
Okay. Question from Tony: can a family override an advanced care directive?
That's probably more of a legal issue than something that I could handle.
Okay.
I don't know. That's a legal issue. Should they be able to? That's an interesting one. Should anyone be able to override an advanced care directive or person's organ donation request? Again, a legal issue. Ethically, I would say no, if the decision's been made by the person had decision-making capacity.
Yep.
But a legal question, sorry.
Yeah, no, that's fine, David. Hard to argue with the point you made all the same. I think question of why wait for 12 months to operate, well, I think that's to allow in-depth consultation. Is that correct?
Or it's really about 17 months before the act commences. That's to train all the doctors and the administrators and put the systems in place. That's reasonably normal government processes. It was to be 18 months, but 18 months would take it up to the Christmas period next year. They brought it forward a bit. But basically, it's still going to be 2026 before the act will commence, and 2029 before a review will be undertaken. And again, unfortunately, from my perspective, 2031 until positive progressive changes are likely to be made.
Okay. Question from Tricia: how is intolerable suffering defined?
Good question.
Yep.
I don't think it's defined in the Act. I don't think it's defined anywhere. It's really up to the doctors, because they're assessing you. You say, I'm suffering intolerably, unbearable suffering. The doctor's saying, well, not quite. This happens overseas. But doctors can assess you as not sick enough. Now, you might have bowel cancer. You might be in remission. but after all the surgery, chemotherapy and radiotherapy, you're going to suffer for another 5, 6 years, and you're elderly. And the doctor's saying, sorry, you're not suffering enough. Yeah. Not good enough. There's no definition, and nor should there be. But this should be a decision for each individual to make about their life. It's an individual's decision about their life as to whether their suffering is more than they can bear. I've got a bad knee at the moment. Is that enough to cause my death? No. But other people might have bad other issues, and they might be thinking, sorry, I need to go. My life is not worth living. It's my decision about my life. So many of these cases might roll out in court issues where, again, not a lawyer, but if the doctor makes a decision and the person or the family decides to challenge the decision about whether the person is suffering unbearably or not. In the ACT legislation, the words unbearable suffering are there, but your disease also needs to be advanced, progressive, and expected to cause death. Putting on those two things together, when doctors are overruling patients or vice versa, look out for the court challenges. Again, not ideal legislation.
So, David, can I just follow up on that? I mean, to me, there seems to be a difference between, say, physical suffering and mental suffering. And physical suffering, you've got a diagnosis of cancer, whatever, you know, it's whereas mental health can be good, can be bad. Will it be a lot harder to actually meet the criteria under mental health challenges because in fact you might not even have the power, you might not be considered to have the ability to make a decision?
Two issues there, Alex, and good points. In the estates around Australia, I think there's generally a 6-month requirement if you have a physical illness that you must have left to live, and 12 months if you have a neurodegenerative condition. In the ACT, of course, that time to death requirement is not there. But you also need to have decision-making capacity. And some people, as their dementia progresses, can be lucid one day. They might not be able to find their way around the nursing home or do their finances the next, but the next day they'll be understanding that my suffering is too bad and I would like to go. So decisions do need to be made when the person has decision-making capacity, regardless of whether they're depressed, regardless of what other issues they might have. As long as they have decision-making capacity for voluntary assisted dying, they're capable of making a decision. But if they don't have that decision, then, as I said, advanced care directives of power of attorney provisions would come into play. And you could let your partner or your children know that in circumstances, you'll like that option of dying if you were to lose decision-making capacity or have some mental illness or so on.
Okay. Question for Magnus. There's quite a few questions, so I am working my way through, David. Under the current law, what process will a terminally ill person undertake to access VAD?
So what process?
Yep.
Well, the process is spelled out in 100 pages of legislation. I'm not going to go through it all because I'm probably not going to ever use the ACT Act. I have my own legal lethal substance that I can use if I so desire. I don't need to go through this burdensome regulatory system. But there will be an education system for all Canberrans. I participated in one committee meeting with the ACT government. It's working out what needs to be done to educate Canberrans on what needs to be done to progress through the VAD regulatory system. And for those who want to do so, I'm sure there'll be plenty of information and pamphlets and support from your doctors and others about how to access this system, how to progress through it. It is a situation where you need to get approvals and witnesses and signatures. And I know in other states, they're getting people in the voluntary assisted dying groups are getting arranged to train themselves so they can witness a person's second signature. And then they've got to get a coordinating health practitioner and a consenting health practitioner, agree on the diagnosis and assessment. I tell you the truth, I don't want to spend the last month of my life going through doctors and then having a doctor inject me with a substance in my arm. I'd rather be spending the last month with my family. And I reckon you're going to be spending a month or two or three for a person who's capable to drive around to various doctors to see them, and you're unwell. In fact, you've got maybe 3 or 4, 5, 6 months left to live, to go through this whole process. That said, the government will be informing us. I'm pretty sure typical Canberra bureaucracy will take over, and all Canberrans who want the option of voluntary assisted dying in this regulatory system will be able to get the information they need.
Like, and David, looking at some of the overseas examples, do people have the option to actually die in their own bed, or do they end up having to go to health facilities, for want of a better word?
Yeah.
That's a good question. I think they can die in their own bed.
Might have been nice.
In Switzerland, if you die, you need to be in one of the facilities there, but you don't need to be ill. In Canberra, I don't see any impediment to you being in your own bed as you die. But if you're not self-administering, you're going to be there with your partner, your kids, and a stranger called a doctor in the room who's going to be overseeing the process. Not really how I want to go. I just rather my family there and nobody else. But that's my personal preference. Other people might want the doctor or nurse practitioner there just in case to oversee what's going on. That should be an individual choice. I'm pretty sure it will be an individual choice. It's important that it is an individual choice, the last moments before, the last moments as you die.
Okay, question from Nina. There appears to be a contradiction between VAD for all people with decision-making capacity and people who lose decision-making capacity should be eligible.
Apparent conflict, but there's not. People who lose decision-making capacity, yes, should be eligible, but they should be eligible because they've have a power of attorney or an advanced care directive already in place. So if I were to lose my decision-making capacity in the future, my power of attorney, presumably my wife or my kids, or my advanced health directive, if they were able to be written under legislation, could make decisions on my behalf. I would have lost decision-making capacity, but I've made the decision well in advance with a power of attorney or an advanced health directive that indicates what I would like as my future treatment option.
Okay, David. Now, look, there's some people have made comments rather than asking specific questions. Just given that I've got 10 questions to get to yet, I'll just move on to the questions. So, what did the religious groups think of the legislation?
So what was that again, Alex?
What did the religious groups think of the legislation?
Well, that's an interesting question. Years ago, of course, it was thou shalt not kill. You are doing harm by killing people, and the usual religious comments that you get. But this time round, in the last Select Committee inquiry, they were almost resigned to the legislation coming on board, being enacted. And what the Catholic group, I think, disagreed with was the fact that they would have to have their institutions refer people who want voluntary assisted dying to the authority who would then oversee voluntary assisted dying for that patient. Now, if you want voluntary assisted dying and you're in a Catholic nursing home, the nursing home can say, tough, we're not giving it to you, and you're pretty much stuffed. But under the new ACT system, and it's again different from what's in the States, they've got to advise you who to go to and put you in touch with the relevant authority. What I've said is perhaps not legally correct. You need to go by what's in the Act. Again, there's 100 pages of rules and regulations there.
Okay, I think it just probably follows at some stage, David, it would be worth following up on this talk as maybe sometime next year so we'll get nearer to the date. But a question from Juan, and I think there's probably a few people can relate to this. People that they visited a nursing home are permanently bedridden, totally bored, and just wish not to wake up the next morning. Should they qualify?
If it's their decision about their life, I think so, yes. Would they qualify? No. And again, this gets down to a matter of the rape in the abortion situation again. Is your life, or are you subject to what the doctors and what the nursing home says about you living? If your situation is such that your quality of life is below your acceptable threshold, why should you have to live if your quality of life is poor and others are saying, no, you must live. Who's controlling your life? That's an important issue.
Yeah.
Should be everyone, every individual responsible for their own life.
Okay, look, and I don't think there's a question in what Rob has posted, but thanks, Rob, for saying that. I'm sure many of us have been in the same situation with a friend, relative, very sick and in a lot of pain as they pass from our world. Susan's question: can doctors charge for the assessment and decision? I presume they can. Somebody will pay.
Presumably pay. Presume they will charge. They're doing work, and probably be covered under Medicare.
Yep.
Interestingly, if all people in Canberra and around Australia who wanted to die were given the option of dying and weren't kept alive unnecessarily, that would be a saving of many hundreds of millions of dollars to the health budget. And we're keeping these people alive, spending money on people who do not want to stay alive, when we should be spending that money on people who do want to stay alive. That's certainly quite anomalous, quite perverse.
Well, that sort of leads into the question that Tony has asked around Hitler, the Nazi Germany, killed people they considered had incurable or mentally deficient, I think was the word that they used. And part of that was to limit the burden on the state, but in the end they did stop doing that. I think it was mainly the religious groups that protested so much. So sort of does it make the advocates of euthanasia a bit uncomfortable that the first euthanasia laws were in Nazi Germany, or according to Tony?
Not at all. I hope everyone here can tell the difference between voluntary sex and rape. One's voluntary, one's not voluntary. The same difference is between voluntary assisted dying and what the Nazis did. Voluntary assisted dying, voluntary. What the Nazis did, murder, killing. The distinction is clear.
Yep.
If you cannot tell the difference between voluntary and not voluntary, you can't tell the difference between rape and voluntary sex, and what the Nazis did and voluntary assisted dying. That argument is really quite pathetic.
Okay, thanks there, David. A question from Agnes is that, are you saying that the current legislation is so complex that almost no one will be able to access VAT, or you've got to be particularly persistent when you may not be in the position to be particularly persistent?
I think, good question. I think time will tell. My gut feeling is, and I think from around Australia, anecdotal evidence might take, if you're really rushing, you'd probably get through in a month, maybe 2-3 months, because you don't want to be dying. You don't want to be putting everything in place straight away. Your people are very sick. They don't want to be spending, again, their last weeks running around to doctor, to consultant, to person to get a signature, to witness, etc., etc. And we haven't been educated on how this 100 pages of bureaucracy will work in the ACT. When we are educated, we might know a little bit better. Hopefully, it's not overly burdensome for those who do want to use this legislation. And don't get me wrong, this legislation will be good for many people. It probably won't be good for me, because I can't imagine a situation where I will be wanting a doctor to assess me. And again, I and many other people have legal, lethal substances that we can use. And that gives me peace of mind. Now, the other issue that's really important here is I'm in a funny position, or the invidious position, where I will need to die earlier than I would ordinarily if I were to lose decision-making capacity. It's always too early until it's too late. I could suicide now by taking some substances. But if I wait too long and I lose decision-making capacity, I won't know how to suicide. So I've got to go earlier rather than later. But that's why power of attorney or advanced health directive provisions are excellent. It means you can go when you've met the conditions that you set out in advance and told your power of attorney or specified advanced health directive.
So David, I can understand if you don't want to answer this question, but a couple of people have asked around, where did you get these lethal substances? So I'll leave it for you, and I'm not sure that we can answer that one. Actually.
No, Alex, I will not be answering that in a public forum such as this.
Yeah, well, I think it's just important that you say that so that people Yep.
And I'll reiterate that again. Legal lethal substances I do possess, but I will not be telling anybody how to get those in a public forum. That would be inappropriate.
Yeah, and I think, yeah, potentially legal issues
Yeah.
significantly. Yep. Thanks, David. I think, as I said, I think it was important that you explain why you can answer that question. Question from Martin, that Canada, he understands Canada has about 4% of deaths under VAD. What kind of level would you expect here?
Thanks, Martin. I'm not sure I'm not sure the figures in Canada or elsewhere. 4%, from my recollection, from when I last saw the figures, was probably a little high. Generally, I think it's about 1% of people might want to access voluntary assisted dying. One half of that, for example, might actually get the drug and use the drug. What figures are useful here? Well, I'm not sure. What figures could occur in Australia? Again, that's up to every individual. Whether it's 0.5% or 10%, doesn't matter if we help people mitigate their suffering. That should be the overriding concern of legislators when developing legislation.
Yep. Look, there's a couple of online debates around the role of religious institutions. I think we'll move on from that and just note that people have made their views, have expressed their views. A question from Glenn that a couple of other people have come around. Doesn't refusing to allow someone to make their own decisions go against the Hippocratic oath of do no harm? Surely it's doing harm by denying someone the right to decide to die. How have doctors responded to that one?
How doctors...
Yeah.
How doctors respond. First of all, Hippocratic oath.
Yeah.
Load of nonsense. Most doctors haven't signed up to that since the 1970s. Do no harm. Again, that's been used mischievously by religious groups. If I'm suffering unbearably, me staying alive is doing harm. Doing no harm is keeping me alive. If I'm suffering unbearably, I want that right to die so that I don't suffer. So Hippocratic oath, not often used these days. And the do no harm, well, for people who are suffering unbearably, keeping them alive is doing harm. So that doesn't really apply.
Okay, just coming back to the whole politics of this decision, and you, as you mentioned at the start, there was people like Erica Betts, Kevin Andrews, and so on. Do you think that this issue could ever come back and people would try to repeal the legislation at some stage? You know, some people feel very strongly about it.
Look, possible, but very unlikely now. It's always so. What the ACT did in legislating what it has done, as again, it's probably done what was politically palatable. Let's say the ACT did what I thought was ethically perfect and allowed all people the right to access voluntary assisted dying. Ethically perfect, but that might still cause the federal parliament to go, whoa, and even David Pocock to say, whoa, even though David Pocock was supportive of territory rights. And I suggested, well, what if the person was 16 years old? Well, I mean, you can, whoever I spoke to, whether it be David Pocock or Katie Gallagher, if you move the age down from 16 to 14 to 5 to 3, where do you draw the line? And I think some politicians might have been quite scared if they'd gone to the ethically perfect option in the ACT first. That said, now it's all in all the other states. Why should the territories be different? The federal government still has the territories' power to overrule those people in the territories and legislate for them, but I don't think it's likely in the near future. They've had their shot. I think that's it. I should just make another comment about the vote in the ACT Assembly. The vote in the ACT Assembly went 20 votes to 5, and the 5 who voted against it were Liberal Party members. Very unfortunate, because on the Liberal Party website, they say they support individual freedom. Well, clearly they don't. These 5 members, Kickert, Cox, Kane, Hanson, Milligan, use their conscience votes to try and deny Canberrans conscience votes about their own lives. I want a conscience vote on voluntary assisted dying, so I can tell Canberrans that they can't have a conscience vote about their own life. That's a level of arrogance that I can't tolerate. Not acceptable. If you want a conscience vote, you should be able to give Canberrans conscience votes as well.
So it's not only VAD that you could argue that applies as well, David. I think there's a number of other areas where.
Oh, but look, most certainly, yes.
Yeah. Is the main focus now to have advanced care directives recognised for VAD purposes?
Whether it be advanced care directives or power of attorney. So we might need to talk to whoever is in power after the election, but certainly people like Marissa Patterson, Tara Chain, Elizabeth Lee from the Liberals about options for advanced health directives, or as Marissa Patterson was putting, the power of attorney provisions. I don't think the power of attorney should just have to be at the last stage. If a power of attorney is acting on your behalf because you have lacked decision-making capacity, why can't it be at any stage of the VAD assessment process? Why should we have people living with dementia against their will and suffering against their will? That does not make Canberra or the world a better place.
Yep, good point by Ron. It's not really a question. Don't forget the harm that can happen if people use the option of unassisted dying and suicide and unsuccessful, resulting in even more suffering. And
oh, most certainly. We have people ask Philip Nitschke all the time, oh, it's all right, I'll just take an overdose of paracetamol and die. So I'll tell everyone here now and then, do not take an overdose of paracetamol. One of the worst things people can do. You could vomit up half of it, the other half will wreck your liver and you'll die in agony over weeks. It is not a pleasant way to die. What we all should be looking for is a peaceful death.
Yep.
And I don't want anybody telling me how my peaceful death should be. Everyone's peaceful death is unique to them. And it's unacceptable that the many people, many Canberrans, they will suffer because this legislation doesn't go far enough.
so, so what do you think is required to get that right into legislation, the right to die?
Well, I think we've got to work hard before this next election to influence who might get elected. And then with the new Assembly after October this year, make a case that while the Act is being educated to Canberrans, and before it commences, that we put in power of attorney provisions and interpret advanced, progressive, and at the end of life to mean also not terminally ill. We want people who are suffering unbearably and people who might lose decision-making capacity to access voluntary assisted dying.
So just a couple of people have made questions around making sure politicians are aware of their views. In the run-up to the Legislative Assembly, we'll do what we've done in the past, and we will have a Zoom session with representatives, hopefully, of all the major parties. We've certainly offered them all the opportunity. Not all have taken that up, and we will open that up to people to ask questions. So you'd be most welcome to ask questions on this subject of our potentially elected representatives. So there's a question here, why advanced health directives won't work with the ACT law? What is the difference between an advanced health directive, and power of attorney?
So an advanced health directive, they are available in the ACT now, but not for voluntary assisted dying. I can say, in such a situation, please turn off my life support. That's my advanced health directive. It's a written direction from me. I cannot say, in such a situation, please inject me with a substance or give me a drink that will cause my death. That is not allowed. That form of voluntary assisted dying, the causing the death directly by injection of the substance, is not acceptable. And what was the other part of your question there, Alex?
Look, sorry, it was a bit further up. I think that was probably the major element there.
Okay.
Thanks. So David, maybe just to come back. So exit the organisation you chair, Philip Nitschke and so on. So sort of what's the focus now that I suppose you've made inroads? You've got to start. Is it just to make the legislation perfect?
Yeah, good question.
As I suppose.
Yeah. Exit's main priority is providing information and support to members on end-of-life choices and their decisions. So supporting members and informing them about end-of-life methods. The Dying with Dignity group in ACT, DWD ACT, and Exit are now working together to try and get changes with regards to power of attorney and unbearable suffering issues as well. So that's what we're going to be focusing on. Legislative change in those particular areas, the unbearable suffering and losing decision-making capacity. More legislative change should be required, but I don't think we can build Rome in one day. It will take some time to get other aspects of the voluntary assisted dying legislation better in the ACT and around Australia. And around Australia, I might say that all the pundits were very enthusiastic about the legislation as it was introduced into every state. Great legislation in Victoria, great legislation in West Australia, and so on. But now they've all had time to look at it. I think they're realising the limitations of the legislation everywhere. And that some people do miss out, and many people are suffering regardless of the legislation. And that's where exit's important, because I have that information I need to make decisions about my own life. But the DWD group here in Canberra and other groups will be still trying for legislative reform, and I'll be assisting in that regard as well.
Okay. Look, I think so. Somebody's just asked around information on exit, and I've just said I think if you Google exit and VAD, it will definitely come up. But I'll send out details of next week's meeting details as well. The specific log on for it. And David, if there's anything else you would like me to sort of send out that gives some background to some of these issues, I think people would be particularly interested. And even I think if you go back and look at the note that came out advertising the program, that'll probably give you a bit of information as well.
And we can certainly send information regarding the Exit ACT submission to the ACT Select Committee, which is over 100 pages of well-argued, logical, rational, objective argument. But of course, most of that was rejected because it might have been not so politically palatable.
Okay, David. Well, look, I think you've really been put through the Spanish Inquisition. You've had a lot of questions, and you've done a fantastic job considering in answering all those questions, and particularly also considering you're not 100%. So, look, I'd like to thank you. And I've also spoken to David. You know, David has an interesting backstory, how he's got involved in these activities and as an ethicist. So at some stage, David, I'd hope you would consent to be a guest on my conversation program, and we can talk a little bit around, you know, what have been the drivers in your past and so on, as we did discuss before, but not tomorrow.
That would be great. Thank you very much, Alex, and thank you everybody for listening. And I hope I've informed and challenged people, and hope I haven't been too intense, but this is an important issue because we do need to do what's right to make us a better society.
Yep, and you can see some very favourable responses there. David, what I do, we provide a donation to a charity to thank the speakers on their behalf. So look, I'll make one too. Would Lifeline be appropriate?
Look, in this situation, Lifeline would be very appropriate. Thank you.
So look, I'll make a donation on our behalf. So so on all our members' behalf. So look, again, David and Jenny for her assistance, thank you so much. A copy of the recording will be available, but perhaps if you wish a copy, come back in tomorrow. I've just got a few things to say, I'm sure David does. So next week, we have Brad Tucker, who's going to be talking about junk and space and the increasing role of the private sector. And for those, Brad is often on the radio. He's probably the best astrophysicist, the most communicable astrophysicist, if I could pronounce that you'll ever hear. He is fantastic. He's spoken before and always been very popular. So I hope to see many of you again next Tuesday. David, get well. Look after yourself.
Thank you, Alex.
And thanks so much again, and look forward to having a chat. Okay.
Thank you, and all the best to everybody. Thank you.